So welcome everybody. My name is Nicole Smith. I am the event and communications coordinator for Spark. We are thrilled to have you guys here. We do these weekly webinars every Thursday at 1 o'clock on a variety of different topics, and we bring in a variety of different experts on these topics. And we are so excited today to have Mark Penner and Jay Kerr-Wilson joining us through the Intellectual Property Institute of Canada to share their plethora of knowledge on intellectual property, especially in this time of COVID. Now, before I hand the reins over to Mark, I just want to say a big thank you to our partners who are the South Niagara Chamber of Commerce, as well as the Niagara Falls Small Business Enterprise Center for pulling this thing together. Special thank you to Loretto Lem, who is with the Intellectual Property Institute of Canada, for bringing all of this together for us. So we are so thrilled. And Mark, I'm just going to hand it over to you right now.
Thanks, Nicole. Hi, everybody. My name is Mark Penner. I'm a partner in the law firm of Fasken Martineau. I work in the intellectual property group. So I do a lot of IP-related work, mostly in the field of patents and trademarks for folks who want to either get patents or register their trademarks or enforce their IP rights against third parties. And today we're going to be talking about IP in the time of COVID, and I'll let Jay introduce himself as well.
Hi everyone, my name is Jay Kerr-Wilson. I'm a partner in Fasken's Ottawa office. I'm a member of the intellectual property group, but also the leader of the firm's communications practice group. So my practice focuses specifically on the communications and internet industries, and I deal a lot with copyright issues.
Perfect. So Jay and I are going to talk about today is really, we're speaking on behalf of IPIC, which Nicole mentioned. That's the Intellectual Property Institute of Canada. And they're sort of the organizing body that is really charged with, one of the charges that they have is to raise public awareness of intellectual property in Canada. So we're going to be talking today on sort of three main topics. One is I'm going to go through pandemic-related inventions, and then talk about some best practices for IP. And then Jay is going to talk about BYOD policies and the copyright and IP issues that are related to that. So just very quickly on sort of pandemic-related inventions, what we're going to go is, so for those of you, we're going to give you IP 101 really quickly. So there's really kind of three main IP rights. There's several IP rights, but really the main ones that people deal with on a day-to-day basis are patents, trademarks, and copyright. So each of those are different rights that protect essentially different things. And you can see that, you know, what I tell people when I'm sort of explaining how IP works is, if you think about your, you know, your iPhone or your mobile device or your iPad or whatever device you're using to watch us today, that's going to be protected by a bunch of intellectual property rights. And so it's not just one IP right that's going to protect those devices. It's really a combination of these things. And so to think about it in terms of what the different IP rights protect is really kind of the key in understanding how they sort of interact together. So the first one we're going to talk about is patents. So patents really are directed to the way things are or how they work. So what do you mean by the way things are? So if you think of if you've invented a new compound, a new drug, let's say, that could be protected through patents. If you discover a new use for an old existing drug, that could be protected by a patent as well. And typically we see those, or we talk about those as utility patents. Those are really, when people talk about patents, that's really what they're talking about. There's also something called design patents, which are called industrial designs in Canada. And those protect the way things look as opposed to the way things function. So I'm going to be talking and focusing mostly on utility patents when I talk about patents. So that's when I talk about, you know, the different patents and what they protect. Patents cover things that they don't cover everything. Not everything is patentable subject matter. There's going to be some restrictions on what you can actually patent. And so you know, most things have some patent component to it, but not everything is going to be patentable. And one of the key aspects is patents will also be publicly available, although there is a confidentiality period in which they're not. But that's opposed to trade secrets or confidential information like the formula for Coke or, you know, the Kentucky Fried Chicken formula, those kind of things. Those things are kept as a trade secret, so they're never publicly available. But the whole idea of patents is to actually get things out there in the public so people can know how to replicate the technology that's covered by the patents. Trademarks are a little bit different than patents, so they cover what we typically associate with as brands. So Coca-Cola, McDonald's, Starbucks, all those things are trademarks, and they're really indicators of source, where things come from. So you know that when you're buying your Starbucks coffee, that ultimately it's coming from the Starbucks family of companies, and you may not actually know where that source is in a lot of cases, but you know that it's coming from one source, and that it's going to be something that, you know, has the characteristics that you've always come to appreciate in association with that brand. There's also one of the key aspects of trademarks, which is the fact that it has to be distinctive. So it has to be distinctive of that source, so that you understand that it's getting that it, you know, there isn't multiple sources of Starbucks coffee. So you're not going to be confused in the marketplace as to which kind of brand of coffee you're buying. That's really the key about trademarks, is they have to be distinctive. And we'll talk a little bit about that when it comes to COVID related trademarks. Finally, copyright, I'm not really going to get into that. That's more what Jay's going to be talking about. But copyright is really directed to artistic, literary, dramatic, or musical works. And software is considered believe it or not, considered a literary work. And so it covers the right to actually reproduce or copy whatever is protected by the work. And so I'm going to switch streams a little bit, focus on patents and trademarks. Jay's going to talk about copyright. So patents, as I mentioned, cover the way things actually are, or the way things function. So you're really, in this context, in the context of the pandemic, you're going to have, or you're going to see, chemical or biological material is going to be protected by patents. Processes, so processes for diagnosing someone with COVID or other things can be protected by patents. And that actually includes software, so software related to maybe contact tracing or other things like that. That could be important in terms of patentable subject matter. And then you have apparatuses like ventilators, PPEs, that kind of stuff, that can be protected through patents. And then if you make an improvement to any of those, that can also be a separate patent. Trademarks, in terms of the pandemic, you know, people, as you may or may not know, have been filing for COVID-related trademarks. The question is whether or not these marks are really going to be distinctive of the source of whatever it is that they're selling. And so when we're thinking about this sort of COVID-related trademarks, think about the distinctiveness issue. Think about whether or not these really are trademarks in the sense that they really distinguish things as a brand from other things, other sources of whatever the goods and services are associated with those trademarks. And really think about sort of whether or not they really would be the subject of a trademark application. This is sorry for the low quality of the screen capture here, but this is from an old collection that I have. This is Calvin and Hobbes, which is a comic strip that was around when I was going through law school. The interesting thing is Calvin's a little kid. Hobbes is the stuffed tiger that's his friend. The interesting thing is that Calvin's father is, in the comic book, we think is a patent attorney, because there's a couple comic strips where he talks about patents and he's reading to Calvin some patent literature, I guess. And so this is kind of a patent joke, really to indicate that patents are really, really important in the biological and life sciences areas. So it's really key for a lot of patents to be, for a lot of biotech companies, patents really is the main asset that these companies are built on. So this is just a couple of examples of sort of corona-related patents. You can see that as I talked about, patents cover a lot of different things. So one of the patents there, the 10,280,000-ish patent, that's directed to coronavirus proteins and antigens. So components of coronaviruses can be patented. Coronaviruses themselves as a family have been around for a long time. People have known about them for a long time. There was, in about 2003, the SARS epidemic started, and that caused people to become focused on coronavirus-related material. And so from about 2003 to now, people have been continuously working on and developing inventions related to coronaviruses. You can see one there is a method for identification of coronavirus, and then you can also have the sort of the component of the virus. Another one is related to the DNA or the RNA, which is the part of the virus which allows the virus to replicate. One of the things is to bear in mind, and I mentioned this earlier, is the fact that patents have this confidentiality period. So for 18 months after you have filed a patent, you're not going to be able to see or to find that patent in a patent search. So there's always going to be a window of about 18 months where you're not going to be able to see anything. So anything that was filed 18 months ago, you're not going to be able to find it. And that sort of window of confidentiality is going to continue to move as we move along. So if anybody has filed something COVID-19 related, we're not going to be able to see that for another 18 months or so. And so these are all obviously things that were filed quite a while ago. I think one of these was 2016, but the Ecker patent that's listed there, that was filed in 2004. So these are now things that have been filed, they have issued, and now people can search them. But you have to remember that anything related to COVID-19 specifically is not going to be uncoverable because we didn't know about it until maybe late last year. So any kind of IP rights that were filed or any kind of patent rights that were filed would not be uncoverable. Next slide, please. So what are sort of the key kind of patents that are related in the era of COVID? So as I mentioned, you can have compounds themselves can be protected by patents. And there's two examples here. On the left is remdesivir, which is Gilead's potential COVID treatment. That's covered by patent. And the interesting thing is on the right is hydroxychloroquine, which has been in the news recently for a number of reasons. But the interesting thing is that patent or that compound was actually identified in the 50s. And so any sort of patent protection that could be related to the compound itself would have expired because patents have a term of 20 years from the filing date. So assuming that they filed a patent in 1950, any patent that would have issued from there likely would have expired in the 70s. And so the compound is free to be made. Anybody can make it, anybody can sell it, anybody can use it, unless there's a new use that is discovered. And one of these new uses could potentially be treatment for COVID-19 infection. If it in fact actually works, and one of the requirements of patentability is it has to actually do something, it has to actually have utility. If it actually does in fact work in that respect, you would be able to get a patent for the new use of an old compound. Other sort of patents related to the COVID treatment area, vaccines and components of vaccines. So vaccines are more than just the compound that we're trying to develop an immune response to. There's also what are called adjuvants, which help in developing the immune response. And those are actually patentable, or if you have developed a new one or an improvement to one, or an improvement to a new vaccine, you've developed a vaccine that works better or has a better immune response, that could actually be protectable. And so you can see just very quickly on the previous slide, Jay, if you just go back, I included modified viruses because there's some suggestion that maybe this was a manufactured virus, not to get into conspiracy theories, but that if you were to actually develop a modified virus, that could actually be patentable as well. Thanks, Jay. Switching gears a little bit, so obviously there are patents directed to mechanical related apparatus and inventions, so ventilators and personal protective equipment could be patentable. So if you've come up with an improvement to a ventilator, say for example, being able to split the ventilator into having one ventilator treat two patients at the same time, that may be an improvement that could be patentable. And I've included as an example there, that's the patent for the N95 mask. So there is protection for some of these masks and eye protection devices and respirators and a whole bunch of equipment that can be used in the COVID-related treatments. Next slide, please. Very, very quickly, as I mentioned, patents can also be related or directed to software. So you can see that a lot of the modeling that's used to predict what's going to happen with folks, what the infections are going to be, if you've come up with a new modeling software, that could in fact be patentable. There is, I noticed when I was doing research for this presentation, there's something called Blue Dot, which is a software product that really has developed an ability to, or they claim, to be able to detect and assess the risk of an outbreak. And so in this time, that's a particularly valuable technique. Contact tracing, you can see like there's a number of suggested apps that could be used. Those could all be patentable. And then finally, artificial intelligence, perhaps the use of machine learning or other artificial intelligence tools to develop new drugs. And there's been some suggestion that these techniques could be used to accelerate either vaccine development or drug development. And then just very quickly, obviously supply chain management is a key right now. So logistics could be quite important. And if you've developed a new way of managing the supply chain system, that could actually be quite valuable. Next slide, please. Now, one of the flip sides as patents basically allow the patentee to stop people from making, using, or selling the patented invention. So in the times of a public health crisis or emergency, having a restriction on the ability of people to do things could be a problem, and that has been some of the discussion in the press. One of the means of addressing that is there's something called compulsory licenses. And those are basically government granted licenses that will allow people to use the patented invention. And so what these compulsory licenses do is they basically say, in the time of an emergency, you can basically get a license to use the invention, but there has to be certain criteria met, one of which is there has to be a declared public emergency. And the Canadian government recently amended the Patent Act to allow the Commissioner of Patents to do just that. And this is what Section 19.4 of the Canadian Patent Act is directed to. There's also non-governmental methods. One of them, which has recently been in the press, is this Open COVID Coalition. And this is a group of industry partners who want to have a sort of open source licensing of IP rights and patent rights for COVID-related inventions. The idea being that everybody sort of puts their patent rights into a patent pool and everybody gets a license to use that. And the idea is to be able to continue to use the IP and not have the patent rights as a means of stopping development of cures and treatments. Switching gears completely to trademarks in the COVID era. So last time I searched the US Trademarks Office, there was about 183 trademark applications with the term COVID. There were about 45 for coronavirus and then about 89 for pandemic. Interestingly enough, in Canada, people have tried to file for a COVID-19 trademark and then some expletives with respect to trademarks. So it's interesting how people are taking the view of trying to protect these terms as trademarks. The difficulty, I think, ultimately is going to be that these terms are really not distinctive. Like coronavirus is a term used to refer to the virus itself. Question whether or not it would be a very good trademark. because it isn't really distinctive, and it's something that people have used quite a bit to refer in general to a class of vaccines, and therefore really not that distinctive of any one player in the marketplace. So you could see that if you're gonna go for a trademark in the COVID era, you really want to get things that are distinctive. Moving very quickly to best practices. So there's really sort of three things that you have to think about intellectual property. One is, what's the role of IP? How do you manage that IP? And part of that is, what is the means to make sure that you're auditing your IP rights? Next slide, please. So there's three kind of factors that three roles really that IP can play. The first is revenue generation. So if you've developed, let's say, a trademark or a patent and you license that, you have people pay royalties. Those royalties then are revenue generation, and the IP is merely one tool for you to generate revenue from that asset. The next one is value creation. So you're effectively creating an asset that has value. So this IP is, it's like the building, it's like your car, it's like your house. It's an asset that has value, and that can be bought and sold, and you can leverage that. And it's really about creating an asset for the company or for your business. And then the third one, which is what most people think of when they think about intellectual property, is that's the competitive advantage. That's the ability to stop people from using what is exclusively yours. So if you have a patent for something, you're the only person who can actually make, use, or sell that patented item. Interestingly, patents don't provide you with a positive right to do something. So if you develop a drug, for example, you don't have the right to put that drug on the market. You may have the right to stop others from putting that on the market, but you don't have the right to do that. That's subject to regulatory approval. So you still have to go through the necessary regulatory approval processes to be able to sell that product in the marketplace. So IP management, what really is IP management? It's really about understanding how you care and control for your intellectual property. And part of that is understanding what the IP rights involve and what they protect and what you need to do to secure protection, right? So how do you have to apply to register a patent? Do you have to apply to register a trademark? That kind of stuff. And what do patents protect? What do trademarks protect? And hopefully we've given you a little bit of understanding of how that works. One of the things that IP management involves is documenting things, recording the details of how these things were developed, when you developed them, the people that were developed, because, for patents, for example, you have to list all the inventors. So anyone who was involved in developing the patent invention, you have to identify those people to the applicable patent office. So it's really important to have that information recorded so that you have access to it when you need it. One of the points with respect to IP is, particularly for trade secrets and for patented inventions, is disclosure. So you don't necessarily want people to be publishing on the internet your secret recipe for whatever it is that you want to make. You don't want to have Coke disclosing accidentally or on purpose the formula for Coke and the problems that could lead to. So you're going to want to have policies in place that address that. You're also going to want to address the ownership issue. So who owns something? So the basic rule is typically when people invent things or create things, they are the owners of those IP rights. Now that may be subject to other restrictions, like for example, in the case of employment or in the case of written contracts, when you hire somebody like an independent contractor to develop something. But you're going to want to understand what's the default position and how that default position can be modified through contractual relations. And then one of the other things is understanding and assessing the value of that IP from the three sort of roles that we thought about: revenue generation, value creation, and the ability to stop somebody. Maybe the IP that you've developed, it may be something that your business stream is not particularly interested in, but you might be able to develop an alternative revenue stream from a licensing, even though you're not in that area. So there may be value there. There may be also value in the sense that it may not necessarily have value for your company, but you might be able to stop others from using that. So there might be some value there as well. So you have to understand the IP right, the value of the IP right in the context of your competitors and your business, and whether or not it actually could be something that generates revenue. Next slide, please. So when you're, as a follow-up point to the disclosure issue, you have to think about how you're going to use these IP rights within your business. And one of the things to understand is there may be third-party IP. So maybe you're licensing in some technologies, typically software, or it could be something else, like you're licensing in manufacturing technology. And so how are you going to use that? How is that going to be disclosed, both within the company and outside of the company? So are you, if you have certain licensed in technology, so third-party rights are coming into your business, are those being used in accordance with the licensing guidelines that are provided, and you're not either misusing them or inadvertently misappropriating third-party IP? One of the things that you should know about patent rights is, even if you don't know about a patent right, you still could be infringing somebody's patent rights. So it's always important to consider that as an issue. Same with trademarks. You may adopt a trademark, but somebody else may have already adopted that trademark or a very, very similar trademark. And so you may be restricted in how you can use that. So these are, monitoring those IP infringement risks can be pretty important. IP audits are one of those things that people should be doing on a regular basis to really look at the type of IP they have and the role within the organization that that IP is going to play. And so you really need to do this in order to get a handle on how are we going to make sure that we're not disclosing things and we're properly using third-party IP rights and all those kind of things. So it's really important to be focused on what those roles that they play in the company, the type of IP that you have. You're not doing anything that you shouldn't be doing, and IP audits are some of the best ways to do that. Next slide, please. Just very, very quickly, conducting an IP audit. These are just some of the factors that you should think about. Think about what you currently have, what you're going to have, what you think you're going to develop over time. Should we register these things? Do we have to keep them unregistered? So, for example, patents, the only way to get patent rights is to actually register them. With respect to confidential information, sometimes in some jurisdictions like Canada, you're not going to be able to register them. There's no registry of trade secrets or confidential information, so you really have to keep them confidential and take steps to make sure that people aren't disclosing them inappropriately. As I mentioned, patents have a certain lifespan, so it's about 20 years from the filing date. So, are the patents currently enforceable? When is the patent going to end? I mean, if it's going to end in the next year or so, that's going to have could have a significant impact on your business, and what others can do once that patent expires. So your commercial advantage, your competitive advantage may disappear. And so you need to think about that, and you need to be aware of that. Hopefully you're not going to, discover that 2 days after the term ends, but about that, excuse me, well before. And then, think about how you maintain confidentiality. What are you doing to, and Jay will talk about this in the context of, you have a disparate workforce, people are working from home, how do you protect all those things? And then, think about ownership. So if people are if your employees are developing IP and that IP is important to the business, you're going to want to make sure that you've covered that off, that, the business owns that IP. And the same thing with independent contractors. If you're hiring people to develop things for you, make sure that any kind of IP that's developed out of that relationship is actually owned by the company. And then finally, just very quickly, think about the value that the asset's going to create. And what of your products and services are protected by these IP assets? So is your main business protected through patent rights? Are your services properly protected through trademarks? That kind of thing. So think about those things when you're conducting the IP audit. Next slide, please. Another thing is, and we talked about a little bit about this, is third-party rights. So as I mentioned, there could be either patents or trademark rights of third parties that you may actually be infringing when you start to conduct your business. So it's a good thing to think about searching, searching IP databases to see what kind of patent rights third-party IP, third-party businesses really have. Think about what kind of trademarks they have. There's a lot of publicly available search databases directly at the USPTO and the Canadian Trademarks Office, the Canadian Patent Office. You can do a lot of those searching on your own. I would suggest, though, that you at least consult. There are lots of companies that do searching. You don't necessarily have to consult a lawyer, although I recommend it. But there are companies that can do searching for you. But certainly, at least do some kind of searching to see what's out there. And then once you've discovered that there may be either inadvertently or otherwise, you may have misappropriated third-party IP. And how do you address that? How do you mitigate the potential risks that can come with that? Next slide, please. One of the keys is when you're entering into negotiation, either licensing or assigning technology, selling technology, what are you representing and warranting to the other side, and what could you be providing indemnification for? So for example, if you're licensing technology to folks, the licensee, the person you're licensing to, is going to want to see reps with respect to validity, the patent rights that you're licensing are valid, that they have the right to do whatever it is that you're licensing them to do, so they're not going to infringe other parties when they're doing whatever they're doing, that you actually own it. And with respect to enforcement, that if there is an infringer out there, so somebody is now infringing your patent rights, you're going to actually take steps to stop that, because that's going to impact the ability of the licensee to maximize profits, because it's going to be eating into its market share. So these are all things that you're going to want to think about when you're in the context of making representations. And sometimes you may be indemnifying folks for, let's say, for infringement. You say, look, if licensee, if you are sued for infringement, we'll indemnify you for any damages that may result or any losses that may result of that lawsuit. And that can be significant in infringement actions, because particularly in the US, patent infringement can come with a very, very hefty price tag. So it's important to understand what it is that you are obligating yourself to do when you're entering into these agreements with third parties. And an IP audit is really one of the ways that you can get a better understanding of how that is. Next slide, please. And these are just some of the goals and some of the steps that can help achieve that goals. We can just skip to I've talked about most of those things. Next slide. And this is just kind of an IP checklist just for folks, just to sort of think about when you're thinking about putting together your IP management policy, and some of the concerns that you're going to have and some of the things that you're going to want to address. And with that, I'll switch it over to Jay, but I will mention that we do have some time set aside for questions at the end, and we're happy to answer any questions you have. Thanks.
Thanks, Mark. So I'm going to talk briefly about the impact of COVID-19 on bring your own device, or BYOD, policies. Obviously, it's, as a result of the pandemic, we've had 5 million more Canadians working from home as of mid-April than was previously in January or February. And a lot of those people that are working remotely are using some mix of employer-provided technology as well as their own technology to continue to perform their job functions. So at any time when you have employees using their personal devices for business purposes to provide services on behalf of the employer or to the employer, then there's a number of risks that come along with those. And these risks can be addressed by just having some forethought and developing the policies to make sure that both the employer and the employee are aware of what is required in order for these technologies to be used as part of the business. And, you know, we've obviously gone way beyond the days when personal devices could only be used for phone calls or texting or email. Smartphones and tablets and laptops can now run basically anything from the home desktop or from the home workstation that could have been run from the desk in the office or the workstation in the office. So word processing, spreadsheets, you know, case in point, I'm running this PowerPoint presentation from my employer provided Surface tablet over my home internet network. So employees are now using the mix of their technology and company assets to create, use, and disclose information across a number of platforms. So you just have to be aware of where that's happening and have a policy in place that will address it and cut off any potential problems that could arise. The big one, and the one that probably people overlook, is when you're using software in the business context, you don't own the software that you're using. You simply license the ability, the right to use it. So whether it's you know, the Microsoft Office or Apple products, and the license is going to be very specific about the uses that that can be used, the number of people who can operate the software under that license. And software companies, they target their pricing around various market segments. So, you know, a home license for a personal use of Microsoft Word, you know, maybe $50 to $75 or $100. A small business license may be more. And then if you have a larger enterprise where you're installing the software on multiple workstations, obviously the price ramps up. So the issue can arise is if you have had 10 licenses for a particular piece of software running in your office, and you've now gone to a work from home solution to deal with the pandemic, and you've doubled the number of people that need access to that software, you may be exceeding the terms of the license in terms of how many permitted users were covered under that license. And this can do two things. First of all, the license is a commercial agreement between the licensor and the licensee. So you could be in breach of your terms of your software license, which could mean you're no longer able to operate the license in any context. But you could also be then infringing the copyright associated with the software license. So typically when you use a piece of software, you have to install it on your machine or your device, and that involves making a reproduction. So reproduction is one of the rights that's associated with copyright. And in some cases, some of the information that may be generated as a result of the license has to be transmitted from one location to another. And if the employee is doing this on behalf of the employer, and the employer is aware of this because they're dealing with the work product being generated by that employee, then the employer could also be authorizing the direct infringement by the employee. Canada has statutory damage regime for copyright infringement, and the statutory damages can be anywhere in the range between $500 and $20,000 per work. So obviously, if you're talking about multiple installations of software that exceed a license, you can rack up some fairly large potential liability on top of the cost and expense of actually litigating the issue. So the takeaway from that is to simply do an audit of your software licenses, and you may have to go back to your software supplier and negotiate an extension or an addendum to the license to cover additional uses of the software in the home environment. The other thing to keep in mind is that where individuals are using their own devices to provide services to the employer and on behalf of the employer, there may be a commingling of personal data information files and company data information files. You may have vital corporate assets that are then leaving the protected shell of the company's firewall and their secure servers, and now they're residing on less secure home networks that may be vulnerable to unsecured or undersecured home Wi-Fi networks. So you need to think about extending the security so that company assets that are being used outside the traditional company environment continue to be protected. So you need to develop and implement clearly written and easily accessible policies to identify and mitigate risks. And this isn't a case where you need to develop the policy and then it goes on a shelf or in an inbox somewhere. It needs to be communicated to the executives and employees, independent contractors, anybody whose activities could engage the issues covered by the policy needs to be informed, and you may need to do a mandatory training session just so people understand the BYOD policy. You likely should have some form of people acknowledging, whether it's just a return email or written acknowledgement that they have read and understood the BYOD policies, just to avoid a situation where someone can reasonably say, I had no idea the policy was even in place. So the policies will include things like, or the checklist will include things like providing employees with the appropriate licensed copies of software if they're using their devices for business purposes. And you may require employees to submit their devices for periodic audits, and have software installed on the devices that the employer can then use to find devices that may be lost or maybe being misused for some purpose. The other thing you need to think about is if you have employees using their own devices for work purposes, and there's a termination of the employment relationship, either a resignation or a layoff or a firing, then you probably need guidelines in place in order to safeguard and likely delete any sensitive company information that could be on the device. And a good policy is to make sure that employees segregate the backup of their personal data, so music, photos, whatever, from the backup of their company information or employer's information, and make sure that the employer has adequate access to the backup copies in case that they need access to it if the device is lost or stolen, or if the employment relationship is terminated. There are certainly applications that people could install on their phones that would create a security risk for the company, and they may want to have either a whitelist or a blacklist approach to software. So the policy is, if you're going to use your personal device for company purposes, employment purposes, then you either have to get pre-approval from one of the IT administrators in order to install new applications or softwares on the device, just so the company has some ability to review and check that against ones that have potential key loggers installed in them, or some other security vulnerability. Obviously, when you're dealing with personal devices, you are going to have to address confidentiality and privacy concerns. You don't necessarily want to be in a situation where you have access to the employee's personal information, their personal photos, health information, any of the other things that may be also stored on the same device as the business. You will need to establish security policies for all devices. So, for instance, at Fasken, our devices are all have to be set. So if they're inactive for a certain amount of time, the device locks and it can only be unlocked with a password or fingerprint or some other kind of security measure. You likely will want to have two-stage authentication. Again, in our case, we have the ability to either have an application that's installed on our phone that has a token that we can use, or you can have a push to a mobile phone to authenticate access, remote access. You will need a recommended approach to content storage. Again, I have two cloud accounts, a personal account, and then a cloud account that's associated with my work for Fasken, so I can keep the two separate. And then, as Mark was saying, where an employee is using their own device, and the thing with this new work at home environment where people are working on their own home, they're not necessarily dividing their day into 9 to 5 is going to be employer time, and the rest of the day is going to be personal time. So if people are developing IP, if they're writing code, if they're designing functions on their own device, on their own time, you need to make sure that you have policies in place there where the work is being done for the benefit of the employer, that the rights and the ownership in that IP that's being developed is being assigned to the employer. So there's no confusion. And that's it on BYOD. So now we're happy to take questions.
That is fantastic. What a great presentation. And I gotta say, I like this last picture. Now I gotta read it. Oh, so thank you so much, Mark and Jay, for your amazing presentation. I'm just going to open it up now for questions. If anybody has any questions, you can feel free to write them in the chat, or if you want to unmute yourself, you're welcome to do that as well. I just don't want to have everybody unmute at the same time. But if you could do that, that would be great. So are there any questions from anybody today?
Hello, can you hear me?
Yes.
Hi, this is Tracy. I really enjoyed this. It really opened my eyes a lot. We're a music school. We have 13 independent contractors, all doing online lessons from home on the Zoom account. And I often wondered, how do we control the situation? Some of them are using their own devices, and some we have provided laptops and iPads to some of the teachers to teach from their home. I feel that being a business owner, we've lost kind of control over when they're in the school, they're using our IP address. We have security, we have policies and whatnot in place. Now that everyone is in their own home, and this came upon us so quickly, the COVID, that we had to act very quickly and to get our school up and running quickly. So we didn't even have time to put policies in place to say, please, join online, like all the policies to create. Do you have a template available for the BYOD policies that would kind of guideline us how to set up something like that?
So, I mean, the policies tend to be very specific to the type of information. We certainly could develop a checklist. I don't know if we, Mark, I don't know if we have anything sort of just on the shelf, but certainly we could develop a checklist that we could provide to Nicole to make available to people that they could, the sort of questions they should be asking themselves. But typically when we would develop a policy, it would be very specific to a particular type of business and the circumstances of that particular business.
Right.
Yeah, I don't think we have a like one size kind of fits all, but certainly it's something that we could quickly put together. I don't think that would be too onerous. But yeah, I agree with Jay. It's going to really depend on, because the risks and concerns is going to depend on what you're actually doing. So it's everything typically we do is pretty bespoke to the situation at hand. But certainly with some these are the things that you should think about. We can put those together.
Right. Would you recommend that we provide the independent contractors with the school devices instead of having them use their own?
So, I mean, the huge benefit of providing your own devices is you can simply dictate what's an acceptable use for that, what it can't be used for. You can say it shall not be used for personal purposes. So if it's practical to do so, that's always the best approach. If you're going to allow people to use their own devices, then you have to put in policies that in effect treat that personal device like it's a company asset. And it sometimes can be sort of hard for an employee to hear that, but this is the core of your business, and there can be critical risk involved in this. And especially in your case where you're dealing with music, which has a whole bundle of copyrights specific to it. So is there public performances going on now that you're doing internet as opposed to in-person lessons? So, you know, you can certainly do it with employees using their own devices if you have the safeguards in place. If you have the option of providing your own equipment, that's always the better option, the less risky option.
Very good, very informative. You gave me a lot of things to consider and to put in place, because this is all new to us as of March of this year. So we're just flying by the seat of our pants, trying to do and put in place the proper procedures and make sure that we're doing everything right, and then incorporate that into our business plan as well, our business policy. So this is a lot to consider. With the independent contractors, because they're not employees, it's very hard for us to dictate to them what they can and cannot do. So we're always treading water there and on a fine line.
Right, and with them, it's really important just to make sure that all of the rights and obligations are spelled out, because they're not in an employer-employee relationship.
Right.
So you need specific guidelines, policies, agreements.
Interesting.
And just very quickly, Jay's too humble to push it, but he did write an article on our website about online education and some of the issues that go with that. So it's certainly worth a read for folks in that area.
Now, is that on the Eventbrite page?
That would actually, yeah, it would be on our law firm's website. So just, you know, go to Jay's bio at fasken.com, and you should be able to track down the article.
Okay, I will do that. Thank you. That will help.
And Mark and I have also co-authored an article that's a version of this presentation as well, or the BYOD component of it.
Thank you.
Okay, thank you so much. Any other questions? I put the website address as well as the name of our two presenters in our chat box. If anybody's interested in just taking that from there. Any other questions from anybody else? Okay, well, I guess that will conclude our webinar for today. So thank you again so much, everybody, for attending. And thank you, Mark and Jay, for all the information. A lot to chew on, but very good information to know.